State is ready, Your Honor. That's ready, Your Honor.
Okay. Ms. Ross, you have opening and concluding.
Yes, sir. May it please the court and counsel. Your Honor, Laken Riley herself has given you all the evidence you need alone to find this man guilty of every single count in this indictment. And as I said in my opening, and what the evidence has shown in this case, is that she did fight. And it is a direct result of that fight that gives you all the physical evidence you need to convict him. And if you only had that physical evidence, you would have enough to convict him. But what you have heard in the last few days in this trial is video evidence laid on top of the physical evidence that corroborates it. Digital evidence laid on top of the physical evidence and the video evidence that all corroborate one another. And the three forms of that evidence in this case, the physical evidence, the video evidence, and the digital evidence, combined twist this very powerful knot that this defendant cannot get out of. There is no way out for him. The evidence in this case has been overwhelming. And the evidence in this case has spoken loud and clear that he is Laken Riley's killer, and that he killed her because she would not let him rape her. And look no further. You have to look no further to his actions 73 minutes before he encountered her on the trail to know what he was up to that day. And so not only does the physical evidence identify him, the video evidence identifies him. His own brother identifies him. His roommate, Rosebelly, identifies him. The people who he was living with condemn him. But his digital evidence of posting selfies of himself wearing what is basically his rapist gear an hour before he leaves his house, that condemns him. He has condemned himself. And what I'm going to do in the time that I have before this court is review the evidence that this court has heard and ask that you find him guilty on every single count of this indictment, not because you feel sorry for anyone, but because he earned it, because he deserves it, and because we have proven it beyond a reasonable doubt. Let's start with the physical evidence. The defendant's DNA is under the right fingernails of Laken Riley. And it is only Laken and this defendant in that sample, and no one else. It was first done at True Allele, and because our Hennis and this defendant are blood brothers, he couldn't be excluded under YSTR. And then it was Diego who could be excluded by YSTR because he has a genetic mutation. But True Allele, when looked further in at the sample, eliminated both Diego and Argenis. So the evidence in this case has been, and is, that it is only the defendant and Laken Riley underneath her right nails. And how did that happen? Because she, in her fight, marked him, scratched him. And the testimony from Ms. Hinkle yesterday when asked, well, how do you get a person's DNA underneath your fingernails? One of the first things she says is scratches or bodily fluid. Casual contact is not enough, and wearing an item is not enough. And how do we know that? The black Adidas hat that we all see for our own eyes on Diego's head doesn't have his DNA on it. I mean, contact DNA isn't the magic bullet that everybody likes to pretend it is in front of a jury. But we know Diego was wearing that hat. You can see it for your own eyes. And I'm going to talk a lot more about that hat and why and how Diego was wearing that hat a little later. It is the defendant's thumbprint on Laken's phone. And this was from the Daubert hearing. This is, first of all, the digital image of Special Agent Daniela Stewart. And that is digital image 597, which is in evidence on one of the thumb drives. And the court heard the testimony that we adopted from the Daubert hearing. And I have here states 28 from the Daubert hearing of October 11th, where Sergeant Stewart of the ACC Police Department, who has been a latent print examiner since 1994, has looked at thousands of prints, compared that image that Special Agent Stewart took on the night of Laken Riley's murder when they finally found her phone after dark away from her body. And he compared it to the known fingerprints of Jose Ibarra, and he did it twice. And he found and explained to the court at the Daubert hearing, which we have adopted as part of this transcript, 15 points of comparison and similarities between the latent print left on Laken Riley's phone and Jose Ibarra's fingerprints. So in order to find this defendant not guilty of killing Laken Riley, you would have to disbelieve DNA. You would have to disbelieve fingerprint evidence. And even if you did that, you would still have this. Quite frankly, she got him. She scratched him. And you heard the testimony from Sergeant Epps and from Corporal Sayan. The left wrist was still oozing. Both of them saw that. And when asked, what's with these injuries by Corporal Sayan, and we played that part of the body cam video for the court to see, Corporal Sayan wasn't coming at him hot. It was super calm and casual. They're out there laughing. They're laughing in those videos. Smoking, talking on their phones, talking to one another, all four of those people inside that residence, chillaxing. And Sayan's like, my friend, do me a favor, show me your hands. My friend, how did you get those injuries? And his first response is that of a monstrously guilty individual. What scratches? Y'all don't see these scratches. We don't see these scratches. So in order to find him not guilty, you would have to disbelieve your own eyes. What scratches, he says? All of those scratches. And there were more scratches than that, because when Daniela Stewart, and those photos are in evidence to you, when she photographed him and made him take his shirt off, there are scratches on his back. His back. And you know what that's consistent with? That is consistent with him asphyxiating her, being on top of her, compressing her chest, and smashing her head in with that rock. That's what that's consistent with. How do you get scratches on the back of your neck? How do you get scratches on your back? Laken left those scratches, and the physical evidence says that she left those scratches because that is why his DNA is underneath her right fingernails. She marked him. She marked him for everyone to see. She marked him for you to see. And the digital evidence that she wore that day also corroborates everything, all the physical evidence and the video evidence. We will never know. We will never know what he did to her on that trail and in what order. And we'll never know what he did to make her stop. Because quite frankly, I am certain she could outrun him if she wanted to. But she didn't. And he did something to her where she knew immediately she was in trouble. And how do we know that? From the Garmin and her phone. Simultaneously, if you put those two things together, which is what this graph is that you saw and that's in evidence, at 9:10 a.m., and there's some seconds in between them that really only matter if you're an Olympian swimmer or a track runner. It's so close together in time, it doesn't matter. It is simultaneous. Simultaneously, she enacts or tries to call 911 from her phone using the SOS function of her iPhone. And we know that from her phone. And simultaneously, at that same time, she comes to a dead stop. She stops in her tracks. And we know that that is the time she meets him on the trail. And how do we know that? Well, we know that from the FBI. Because there is a chart that I'll show you a little later in my closing argument, where at 9:10 a.m., their digital profiles overlap one another. They have met in that woods. His from his timing advanced data from his phone. And remember, the moment he enters the forest, his Wi-Fi is no longer active. And so there's no Rubin data from about 8:55 to about 9:40 a.m. And that is evidence of his guilt too. The fact that he's in that forest, that means he's in the forest. And we know he's in the forest because he has no Rubin data. And we know he's in the forest because his timing advanced data puts him there. And they meet simultaneously, digitally,
on that trail at about 9:10 a.m. And so something happened, and this is her Garmin watch. And we know there was a fight because the way that it looks, look at this, on the trail, she's still on the trail till about 9:14 a.m. And then her Garmin starts moving off the trail. And he takes her off that trail 65 feet. 64 feet and 11 inches to be exact. 65, close enough. And he does that for only one purpose. And that is to isolate her so that he can victimize her. And that is exactly what he did. But the true allele under her nails, as damning as it is, isn't all that you have. And you could put that aside and the fingerprint aside, although there's no reason to. On the jacket that he is seen throwing away about 12 minutes or 14 minutes after her heart stops beating. And it is no coincidence that he is in that forest until her heart stops beating at 9:28 a.m. And it isn't until around 9:40 that he emerges. He is with her that entire time. But about 14 minutes afterwards, he is seen on video dumping a jacket that you have here in evidence that you've seen a lot, so I'm not going to show it to you again, that has a mixture, and this is traditional DNA. This is not true allele. This is not probabilistic genotyping. This is traditional DNA, and it is a mixture between only two people, Laken Riley and this defendant. And it's no mistake that it is blood, a mixture of their blood on that jacket. And on that jacket also are 29 hairs that are consistent with Laken Riley that all have been not all of them, but several of them have been forcibly removed from her head. And they were wrapped around the button that you see in some of the photographs when Officer Davis testified, the way that he saw it. And it is a rare day that as a prosecutor, we ever get such great evidence of tampering with evidence. But the defendant himself is on video, and here it is. And now I guess the defense will have you believe he just threw away that jacket right at this moment just because he just didn't want it anymore. That's not reasonable. He threw away that jacket because he knew exactly what was on it. He knew it was his blood, he knew it was her blood, and he knew he had to get rid of it. And he also knew that he had to get rid of his gloves, and so what he does further on in this frame is you can see him take them out of his pocket and throw it in the bushes. And on those gloves is Laken Riley's blood. He threw away the gloves because he knew what he had done. He knew her DNA or her blood would be on that, and he got rid of it. That is what we call consciousness of guilt in our business. He threw away those items because he knew he had killed her, and he threw them away because he didn't want anyone to find him. That's why he did it. And what's so fascinating about this video is the part where he looks at the hat. Let's talk about that. Guess what he didn't throw away? The hat. It's his brother's hat. Diego said it in the interview. That's my hat. He wears his own brother's hat to go kill someone. And he looks at it. Oh, no blood on that. He didn't see any blood on it, although there is her blood on it. Puts it back on his head. Doesn't throw that away. And then lets his own brother walk around with it the next day. And the fact is, if Diego had not been wearing that hat, we may have never caught these people. We may have never caught him. But Diego was wearing that hat. You think for 1 minute, Diego would have to be the dumbest killer on the face of the planet if he killed Laken Riley and was still wearing that hat around. Because what Laken Riley's killer did was he got rid of all the evidence. At least he thought he did. And that hat right there, he couldn't see her blood. And he gives it back to his brother. And luckily for all of us, his brother decides to wear that hat that next day. And we know his brother wasn't wearing the hat on that day because you got to see the video for yourself where Diego goes to work on the day of Laken Riley's killing. He's at work and he's wearing a completely different hat. And each day that we have of the videos of where he's going to work, he's wearing a completely different hat. So this defendant, this killer, gives a hat back to his own brother that he was wearing when he killed Laken Riley. And I have to take a moment. You know, the officers in this case have done a lot of things. They dived into dumpsters. Daniela Stewart told you she was on her hands and knees on that crime scene looking for rocks that were similar. Couldn't find any rocks around where Laken Riley was murdered. A lot of it, you know, Sergeant Timothy Johnson, whose testimony we adopted from the hearing in October, you know, just hitting the streets looking for things. Zach Davis, dumpster diving. It was a combination of good police work and, quite frankly, just luck. We were lucky that Diego decided to wear that hat. And do you think for 1 minute if Diego had killed her, he would have put that hat on? No. And looking in the video that you see, and you saw slowed down versions of it, Diego has tattoos on the back of his neck. They are not in that video. Rosebelly herself, who knows both of these two, identified this defendant in that video. And if you're concerned about whether she's right about that, well, the FBI's digital profile of this defendant's device hovers over that dumpster at 9:40 a.m. It's him, and there is no doubt that it's him. Here is the FBI profile, digital profile from the CAS team of the defendant's device now over the dumpster. In the center of this is D1, 9:40 a.m. He's at the dumpster that we just saw him at, dumping bloody clothes. And how do we also know he's back at his apartment at that time? Because Special Agent Hipkiss, who extracted 1B7, said at 9:58 a.m. the device is plugged back in and charging, which means he's back home. But he's not done. And before I go on to the other videos, these are all the selfies of this defendant on his phone 1B7. And I understand, and I suspect maybe the defense will argue, well, Judge, you know, other people used his phone. Yeah, they did in October. And then the other 2 months that they want to talk about are other 2 accounts. Oh yes, Diego has a Google account that has been accessed from 1B7. Both of those accounts that they talked about, one a Facebook, one a Google, I can't remember exactly, but there were 2 of them. Rosebelly had one and Diego had one. One of the accounts was closed in January, and the other one of Rosebelly was closed in February of February 12th of that year. So on the day in question, on February 22nd of 2024, there is zero evidence, no evidence that anyone other than this defendant was using that phone. And any attempt to argue that someone else was is just pure speculation, because the only activity on the phone prior to leaving is him taking that selfie at 5:30 in the morning. That's it. There's no one texting, no one WhatsApping, no one calling in the time that he's out hunting and killing, because he's holding the phone and he's a little busy because he's looking for victims. He's looking for females. Nobody else is using that phone. And the FBI said, and the phone tracks his own video. You could put the video of him at the bus stop, which I'll show, and put it with the digital profile of the phone, and they track one another. So the videos and the digital profiles track one another because he's holding the phone at the time. And this is what he does when he gets back. His phone is plugged in at 9:58 a.m., but he's not done destroying evidence. That shirt that he's seen wearing with the black and white pattern in the video, in the dumpster video, a few minutes later when he comes out of his house at 10:21, he's changed. And now he's wearing the clothes that he's actually arrested in. This is him, 10:21 a.m., and he's got a bag in his hand. I really wonder what's in that bag. Never found that bag. And he didn't want anyone to find that bag. And how do we know that? Because he's walking towards a dumpster. And Sergeant Norris said that dumpster and that part of the apartment complex had been picked up about 45 minutes later that day. So they weren't able to get and see what was in that bag. And no one ever found what was in that bag. But you know what was also never found? The striped bag that he's wearing over his, that sling bag that he's wearing in both the dumpster video and in the bus stop video. That bag was never found, ever. And I suspect it's because it was in that bag that we just see. And here he is coming back 3 minutes later, and there is nothing in his hand. He's gotten rid of the rest of the evidence, because that's what guilty people do. So the digital evidence that I have talked about, in summary, from Special Agent Jay Burney of the CAS team, it is his opinion that he left that house at 6:52 a.m. and that he returned around 9:50 a.m. And that there is no Reuben data on that phone from 8:55 to 9:40, which is consistent with him being in the forest. This is the slide from, and this is what summarized Special Agent Burney's testimony, that at the time, at 9:10 a.m., so on this slide here that was before the court, page 29 of his exhibit, at 9:09 a.m. to 9:12 a.m. is where on the trail Laken Riley and this defendant meet, digitally and in person. And so that is pretty much the evidence. His DNA is there, his thumbprint is there, and he's on video dumping evidence associated with the crime shortly thereafter. I want to talk to you about the charges in the case, and this is usually when I would go on much longer with a jury, but I don't think there's a need to do that with this court. These are slides that I use in murder cases where I close all the time in front of juries. The court is aware that in the state of Georgia we have malice murder. The defendant is charged in count 1 of this indictment with malice murder. Malice can be proven in 2 ways, as you know, but we really don't even need to talk about implied malice in this case. This is express malice. Everything this defendant did to Laken Riley on that trail showed his intent to murder her. And what express malice is simply the intent to kill. And so what evidence is there that when he interacted with her on that trail and he drug her off that trail that he intended to kill her? Well, look no further than the evidence of the medical examiner in this case. He put huge holes in her head with a rock. And he did it more than once. And there could be no other reason to do that other than to silence her forever, so that she could not call Sergeant Maxwell or anyone from the University of Georgia Police Department and report that he tried to rape her. Because guess who did call the police on him? Tejaswi. And we're going to talk about that count in the indictment. And he ran away after she confronted him at the door. So he had a motive to kill Laken Riley, but you don't even have to go that far. All you have to do is look at his actions and look at the state's exhibits that we admitted through the medical examiner and look at those 9 holes in the left side of Laken Riley's head. That's intent to kill. And the rock sure is a deadly weapon, especially when used that way. He used a rock like it was a hammer. And that's what he did to her. That's intent to kill. The petechia, also, because these are concurrent causes of death. Asphyxia. He asphyxiated her in some manner. Again, we'll never know everything he did, how he did it. But he asphyxiated her, we know enough. That caused petechia in both of her eyes and even at her lips. That is a tremendous amount of petechia that she has there from a compression or a strangulation injury. He was depriving her body of oxygen long enough to form those wounds on her. He intended to kill her. There is no other reasonable explanation for that conduct. We have also charged 3 counts of felony murder in this indictment. I'm not even going to define it for the court because I know you know what it means, so I'm just going to go straight to the felonies. And they are kidnapping with bodily injury, aggravated assault with intent to rape, and aggravated battery. First, with the kidnapping with bodily injury, that is exactly what happened in this case. And that actual felony precedes the murder in time, because he didn't murder her on the trail. He took her 64 feet and 11 inches off the trail for the purpose of victimizing her. That is asphyxiation, that is recognized under our law, and it is what permitted him to do the things to her that he wanted to do all along. And if he hadn't had asphyxiated her off that trail, he would have been interrupted. So it is a kidnapping with bodily injury. And I have a crime scene photo here from, again, Daniela Stewart, where she shows marker 1, which is Laken Riley's other AirPod. And that's how we also know there was a struggle on the trail. Sophia and Lily find, and we know Laken was listening to music when she was running. They find her AirPod, one of them, in the middle of the trail. And there's a photograph in there. A little towards the side, but still on the trail. AirPod number 2 is found by Daniela Stewart, where marker 1 is off the trail. So there was some kind of struggle between the two of them on that trail, and it's also shown on her Garmin, where she loses her AirPods on the trail. And he takes her off that trail. And we'll never know exactly how he took her off the trail. Did he pick her up and carry her? Did he somewhat drag her off the trail? Did he somewhat push her off the trail? But we know that he took her 65 feet because we know that's where her body was found. And also Daniela Stewart saw like a leaf. She called it a displacement of the leaves, and she marked it with those orange flags, but no real dragging marks. So that's a kidnapping with bodily injury. Taking her off that trail, and in the commission of that crime, he kills her. He is guilty of felony murder, with the underlying felony being kidnapping with bodily injury. It's not contested that she has bodily injury. But the aggravated assault with intent to rape, there were a lot of questions about, well, could her shirt be up from dragging her? I suppose the defense might be, well, I killed her, but I didn't intend to rape her. Well, that makes no sense. Because the only thing that makes sense about why these two individuals don't know each other, never met each other, had this encounter on this trail at this moment while Laken is out for her morning jog, is because he wanted to sexually assault her. What evidence do we have of that? What has been left behind from the struggle that we can discern that? What circumstantial evidence? Well, her clothes are in two different directions. And it is important to talk about her clothes. And we're not talking about her clothes in order to shame her as a female. No. It's evidence on how she wears her clothes. She would wear running tights when she ran because that's what's comfortable. And that's how you run. And she would wear them over her navel because when you're running, you want your clothes to stay put. And she wore a Lululemon jacket, and she wore 3 layers of clothes that day. And it's important to talk about that from an evidentiary perspective because these are tight running clothes that are designed not to move. Not to move. And if they want to say dragging may have caused one of the layer of clothes to come up, all right, I'll give you 1. But I can't give you 3, and I can't give you the clothes going in 2 different directions. Her shirt was up. Her running bra up. Her jacket up, and her breasts were exposed. In a way that you saw in Sergeant Maxwell's body cam video, and in a way that Special Agent Beyer testified to the court, and he photographed them. They were twisted all together in a knot almost, above, and like almost tying down or pinning down her shoulders. That is not an accident, and that is not from dragging. And if you even want to think that that was from dragging, then how do you explain how her tights are down below her navel? She never wore them that way. Her underwear is pulled up, and you can see it in the body cam video, and you can see it in the photos from Special Agent Beyer, and her underwear has been torn. He did that to her. He did that to her after he drug her off the trail. And he did that to her because he wanted to try to rape her. And we don't have to prove a completed rape, and thankfully she wasn't raped. But he tried to do it, and he was unable to complete it for some reason that we will never know. Maybe he didn't like the fight. Maybe somebody ran by. Who knows? But he didn't complete it, and we don't have to prove that he completed it. Injury to Laken's pubic bone, State's Exhibit 316, that also corroborates that he attempted to rape her. Why is that injury so low? All these injuries to her stomach, these linear injuries. That means her shirt was up when he's on top of her. Could it have been the bag? Possibly. It's consistent with a metal object. Never found the bag, don't know. But there's no reason for her to be exposed that way unless he was trying to sexually assault her. That is the evidence of aggravated assault with intent to rape. It's the only thing that makes sense about the encounter, but there's all that physical evidence that supports and corroborates that that's exactly what he did out there. Aggravated battery. I could talk forever about aggravated battery and disfiguring her skull. Just look at State's Exhibits 305 and 307. I really don't need to say anything else. Look at those two exhibits. That is the very definition of aggravated battery under Georgia law. He is guilty of aggravated battery and felony murder, with the underlying felony being aggravated battery. Obstruction of a 911 call. The SOS call was made, no doubt about that. We got that from not only Laken's phone, but we also got that from Kevin McCreevy from the 911 call center. She made a call. She made a call, it was answered. You heard the call. Kevin McCreevy testified. The caller hung up on the 911 center. That was his testimony. The 911 center called Laken back twice, and that you could see that in her phone. And neither call was answered. Who hung up the phone? Well, he did. How do we know that? State's Exhibit 28. It is no coincidence that his thumbprint is on her phone where you would go to hang up an iPhone. And also on that call, that is about a minute call, you hear him say, "Yo, Tango." I have. Yeah, you do. You do have. You had her phone. And he hung it up. And when 911 called back twice, no one answered. And her phone is separated from her body. So her body is in, she was murdered by the tree. She was moved and hidden and put leaves over her. And it worked because it took Sergeant Maxwell 20 minutes to find her, and he had her digital profile. And we didn't play the whole thing, but he testified it took him 20 minutes. And because he hid her, because he didn't want anyone to find her. We were lucky there too. But he separated her from her phone. Her phone was so far away from her, it took them hours to find it. You heard Sergeant Norris, I was walking through shining a flashlight. I almost stepped on it. You saw the video of his body cam. You saw how dark it was out there when they found her phone. He separated her from her phone because he didn't want her to complete that 911 call. And she didn't. He's guilty of that. Tampering with evidence. I've already covered this. It is rare we get this on video, but we got it on video. He's throwing away the bloody jacket. He's throwing away the bloody gloves. That's how it is alleged in the indictment. He's guilty of that. And I've already covered this. There he is. No tattoos, been identified, looking at the hat that he decides to keep. Here he is on social media. If you have any doubt, that's him wearing the hoodie and the black Adidas hat. Did you a huge favor there as the fact finder. It's 5:37 a.m. on the day of the murder. He's about to go out, and that's how he's dressed. He is alone in all of these times. Trail cam video, Tejaswi and Sally, the other female runner that encountered him at 8:24 a.m. where he is what? In the woods. And how do we know that? Because when Tejaswi calls the police on him at about 8 o'clock in the morning, he vanishes and disappears into the back, and Sergeant Rabu testified in the direction of the IM fields. And he stays there. What's he doing there? What's he doing there? Well, he isn't running. I doubt he's bird watching. He's sitting there waiting for someone to come by because his first intended target, he wasn't able to get. And I'm going to ask if there are any cameras up. I want to show a portion of something that I don't want the peeping victim to be seeing, the Tejaswi.
So I will direct media to not publish this as well as
all right. So are we good? We're good. Okay. I'll let you know when it can come back up.
Hey, I'm sorry. Hey, can I come in or are you? Alrighty. So I'm just gonna get one thing over the radio. 6427, I believe it's gonna be the north facing at the end of the building. Hey, so you okay?
I'm okay.
Oh, gotcha. I understand it would be a little bit scary. I'm just gonna be asking a couple questions, get some clarifying information, okay? So you're taking a shower, correct? And you heard something going on?
Yeah, I heard like something was moving, and I just heard it was someone from upstairs. I usually hear that. And then when I actually came out, I heard it coming from the door.
Are you hearing it coming from this door?
Yes.
Okay.
So I went to see to the people, and then I saw actually someone was like crouched down and then trying to like, I think I just open it.
Okay.
And then I thought it was just maintenance. I thought of opening, but then I was like, why would they do that right when you first knock?
Yeah.
So, and then I said, excuse me. And as soon as I said that, they tried to duck down, but I could see them ducking.
Mm-hmm.
And then they went away. And then after that, I tried to get the phone. Then when I was standing by the door, then I could see them peeping, trying to peep and take a look.
They're trying to look into that. So at no point did they ever enter your
No, they
your
didn't.
okay, good.
In this frame, you can see, as some people would say, clear as a country mile to the back of Building S from Tasia Sweet's apartment. She absolutely saw him looking in her apartment. And when she said he was ducking, you can see that for yourself in the trail cam video. And the peeping Tom, and I'm gonna, okay, y'all can come back up now. Are we good? Okay. Is important as a charge, and you can see how scared she was and frightened in that video. She was unnerved about what happened to her. She's in the shower. And that's when he decides to try to open her door. Again, he had been outside her apartment for an hour. The testimony from Sergeant Rabu, and you saw this video yesterday from GBI Cyber, he first appears on the trail at 6:52 a.m. according to that trail cam video. Guess what that coincides with? His digital profile from the FBI. His phone is moving at the exact same time that you see him on this video for the first time. And what this does is, it is a crime, and he is guilty of that crime, but it shows his state of mind. You watched the video yesterday. He's there for an hour. You see students kind of mulling around, some of them waiting for the bus, a lot of them on their phones. He is not pressed. He doesn't care. He talks to no one. He interacts with no one, and he keeps circling back and forth from Tasia Sweet's door to the back of her apartment, Tasia Sweet's door to the back of her apartment, and he does it 6 times, and he tries to open her door at least twice that we can see, and when she says he is ducking, there's her window, you've seen that image as well. Here is the part of the video at 7:54 a.m. You see him ducking. She is absolutely correct. And what's he wearing? He's wearing the hoodie, a black hat, black gloves, and carrying a cup. His digital profile puts him right over her apartment at these pertinent times. His Reuben data is collecting at this point because he's not in the forest. And so it's him because of that as well. His digital profile puts him there. He's wearing the same clothes. But if you have any residual doubt that that's him in the video, boom. His DNA is on the cup. The white cup that you can see him carrying in that video was found smack in between Tasia Sweet's apartment and Laken Riley's body, and it is his DNA on that straw. And yes, it's a mixture. It's not Diego's, it's not Arhemis's, it's not anyone related to him. It's him and some other male, and there's alcohol in that cup. He's drinking alcohol at 7 o'clock in the morning while he's out prowling and hunting females. It's him. No doubt that it's him. And I want to talk about the gloves, because the gloves that he chose to wear that day, you heard from Alexander Coven of the Crime Lab. Luckily again for us, They were cheap. They're not latex. There's some kind of polyethylene, like plastic gloves that tear easily, is what he said. That was his scientific testimony. And those gloves were torn. And you saw photographs of them where Katrina photographed them at the crime lab. And because those gloves were torn, he was able, and maybe they were not torn when he was holding the cup, maybe they got torn when he's holding these rocks and murdering Laken Riley when she is fighting him. But at some point they were torn, and we know that because after they're recovered in the bushes, they go to the crime lab and they are photographed and they are examined. And the first person who sees them at the crime lab is Valencia Johnson, and she says they were damaged. The second person who sees them is Katrina, and she photographs them. And you have the photographs and evidence to use. You can see for yourself that they were damaged. So what in the world is he doing outside a co-ed's apartment, wearing plastic kitchen gloves, a hoodie, covering up his face, and skulking around? He is trying to get her. And when he couldn't get her, he ran away into the forest, and he stayed there until he encountered Laken Riley about 73 minutes later. And then he did all of the things that we've already covered in the indictment. And I want to talk to you a little bit about circumstantial evidence, but not in a way that I would talk to a jury about it. There is no legal difference between circumstantial evidence and direct evidence. It's not bad. It's just different. And in this case, it is powerful. And it is layered upon layer upon layer. And there is no way out for him. He is guilty of everything in the indictment. I want to talk to you about the defense case. And this is actually something that a scientist said yesterday. It's amazing how trials are, how people say things you never expected, and they just have a life of their own. Trials. Ashley Hinkle yesterday, I think it was on Cross. The absence of evidence is not evidence of absence. I couldn't say it better myself. I suppose their defense is Diego did it, because that's all we've been talking about is Diego. And yeah, Diego was a suspect because he's wearing the hat that they saw. But eventually, you know what the officers didn't do in this case? They did not turn a blind eye. They got Diego's phone, they got Diego's DNA, they interviewed Diego, and they followed it to its natural end. They looked through hundreds of hours of video. You saw the chart that Detective Norris put in on Friday of all the videos around the IM fields. And there were multiple cameras. He and Sergeant Rabu and Special Agent Lucas Beyer, they watched hundreds and hundreds of hours of videos. Guess who's not anywhere near the IM fields at the time and on this day? Diego. He is nowhere to be found. And the only way that Diego could have done this crime, and the only way that it could be even like a reasonable hypothesis that he could have done this crime, is if he had two things. Number one, magic pixie dust. He would need the magic pixie dust to put his brother's thumbprint on her phone. He would need the magic pixie dust to put his brother's DNA underneath Laken Riley's fingernails. And he would also, in addition to that, because of the video evidence, he would need one other thing. And that would be Harry Potter's invisible cloak. He would have to put that on and go to the IM fields and do these things because nobody sees him. And I want to talk about Stephanie, because what your decision is today is it's Stephanie versus science. Stephanie, who wants to invoke the fifth when asked about whether she had a sexual relationship with Diego, which goes to her motive for being here. And the conversation, which is so interesting, that she said she had with Diego on the night of the 22nd, after the police were in her apartment, and we know it had to be the night of the 22nd because it was after Laken Riley's body was found, which was noon on the 22nd. But before 8 a.m. in the morning, when Sergeant Johnson sees Diego wearing that hat that his brother left in the apartment after killing her, and she says between that time she had a conversation with him at some point. Well, guess where Diego was that day on the 22nd? You saw it for yourself. He was at work. And he was at work till about 11 p.m. And it was Stephanie's birthday, and she was out drinking. And she drank so much, Judge, that she even said, and the GBI, Annie Mormon, confirmed, she was drunk when she was talking to the GBI the next day still. And maybe she did have some semi kind of conversation with him. And even then, if you take her at her word, it's not a confession. There is no evidence that he did anything except be a brother to him. And it's pretty low down that you're going to take the killing hat and then let your brother wear it around in the apartment complex the next day. But that's just what a killer would do. So to believe her, you would have to disbelieve all of that. And then today we heard some unreliable inmate hearsay. Not reliable. And cannot weigh anything against the mountain of forensic evidence, video evidence, and digital evidence that you've heard in this case. And yes, here is Diego wearing that hat. You think he'd have worn that if he had known what was on it? He didn't know. Glad he wore it. He didn't know. And so that completes my portion of this closing argument, and I will see to defense and see Your Honor at rebuttal. Thank you.
Ms. Beck.